Welcome to the deep dive. Today we're going to be digging into quite a specific but really important area of property law, proprietary estoppel.
That's right. Yeah. Proprietary estoppel. It sounds a bit technical, maybe,
A little bit.
but it's essentially an equitable idea. It's a way the courts can step in and give someone rights over property, even if there's no formal written contract. But, certain things have to be proven first.
Exactly. It's about fairness, isn't it? When the strict letter of the law might seem, yeah, unfair.
Precisely.
So our mission today, and we're drawing from some excellent notes here, topic 6, proprietary estoppel UG laws, VLE.pdf, is really to unpack proprietary estoppel. We want to look at the key ingredients, some really important cases, lots of cases in proprietary estoppel, and also what happens at the end, the remedies you might get under proprietary estoppel.
Yeah, and we want to make it, clear and hopefully memorable. Understanding proprietary estoppel is actually pretty relevant in the real world.
Definitely. Okay, so where do we start? Establishing this thing called an equity. What does someone need to show to even get a proprietary estoppel claim off the ground?
Right, establishing the equity. This is the first hurdle. So to get this equity through proprietary estoppel, a claimant, the person making the claim, needs to prove a few core things. And the classic starting point, the case everyone learns first, I suppose, is Ramsden v. Dyson. That's Ramsden v. Dyson from way back in 1866.
Ramsden v. Dyson, 1866. Got it. And there was a specific speech in that case, wasn't there? Lord Kingsdown?
Yes, Lord Kingsdown. It was actually his dissenting speech in Ramsden v. Dyson, but it's become, well, incredibly influential for proprietary estoppel. He talked about a scenario where, say, a landowner leads someone to believe they'll get an interest in the land.
Yeah.
And that person believing this maybe spends money or builds something on the land and the landowner knows about it, doesn't stop them.
Right. Just lets them get on with it.
Exactly. Lord Kingsdown said equity, fairness would then step in and make the landowner stick to that promise or expectation. That idea from Ramsden v. Dyson really underpins the whole doctrine of proprietary estoppel.
Okay, so Ramsden v. Dyson sets the stage. What are the specific elements, then, that have sort of evolved from that?
Well, breaking it down from that foundation in Ramsden v. Dyson, the first key element for proprietary estoppel is usually called representation or assurance. Basically, the owner of the property has to have said something or done something that creates an expectation in the claimant's mind that they'll get some right or interest in the property.
And does it have to be a really explicit promise, like, I promise you this land?
Not always. No, it can be a clear statement, sure, but it can also be more subtle, like an impression that builds up over time, and the owner knows the claimant has that impression and doesn't correct it. The case Gillette v. Holt is really good on this point. That's Gillette v. Holt from 2001.
Gillette v. Holt. Okay. So the assurance can be less direct in proprietary estoppel. What's next after assurance?
After assurance comes reliance. The claimant has to have actually relied on that assurance or representation. They need to have changed their position or acted differently because of it.
Right. Makes sense. You believe the promise, so you did something based on that belief.
Exactly. And there's an interesting point here from a case called Greasley v. Cook. Greasley v. Cook from 1980.
Greasley v. Cook.
Yeah, Greasley v. Cook suggests that once you've shown there was an assurance that was intended to be relied upon, the court might actually presume reliance. It's what they call a rebuttable presumption.
Rebuttable presumption. So the court assumes reliance happened unless the other side can prove it didn't.
That's pretty much it, yeah. The burden sort of shifts. The defendant, the landowner, would have to show the claimant didn't rely on the promise or would have done the same thing anyway. It's a helpful point for claimants in proprietary estoppel.
Okay, so we have assurance, then reliance. What's the third element for proprietary estoppel?
The third one is detriment. The claimant must have suffered some kind of disadvantage, some detriment, because they relied on that assurance.
Detriment. And what kind of disadvantage counts? Is it just about losing money?
No, it's viewed quite broadly in proprietary estoppel. It can definitely be financial spending money on improvements, working for low wages, that sort of thing. But it can also be personal. Think about life decisions. There's a case, Grant v. Edwards, that's Grant v. Edwards, 1986, where part of the detriment involved moving children to a new school.
Grant v. Edwards. Wow. Okay. So big life changes count.
They can, yeah. But you have to contrast that with other cases, like Coombs v. Smith, also 1986. Coombs v. Smith. There, the things the claimant did, like leaving her husband or having a child, weren't seen as sufficient detriment in reliance on the specific promise about the house.
Ah, so there's a link needed between the promise, the reliance, and the specific detriment claimed in proprietary estoppel. Comparing Grant v. Edwards and Coombs v. Smith helps see that.
Exactly. The detriment has to flow from the reliance on the assurance. But the courts do look at detriment quite broadly overall in proprietary estoppel. It doesn't have to be easily quantifiable in money terms.
Okay, assurance, reliance, detriment. Is that it?
Almost. There's one more, and it's arguably become the most important kind of overarching element in modern proprietary estoppel law, and that's unconscionability.
Unconscionability. That sounds serious.
It is. It basically means it must be fundamentally unfair or unconscionable for the property owner to go back on their word and insist on their strict legal rights, given the assurance, the reliance, and the detriment that's happened. Unconscionability is often described as the bedrock of proprietary estoppel.
So unconscionability ties it all together, even if you have the other three. If it wouldn't be sort of deeply unfair for the owner to change their mind, the claim might fail.
Yeah, that's the idea, yeah. Unconscionability is key. And a case that's relevant here is Taylor Fashions Ltd v. Liverpool Victoria Trustees Co. Ltd. That's Taylor Fashions from 1982.
Taylor Fashions, okay.
Taylor Fashions is interesting because it suggested that proprietary estoppel could potentially apply even if the owner didn't initially realize what the true legal position was. The focus shifts more onto whether it's unconscionable for them to rely on their rights now, having allowed the expectation to continue. Unconscionability is the touchstone.
Right, so the focus is on the unfairness of going back on the expectation. And you mentioned expectations. Can the assurance in proprietary estoppel be about inheriting property, like after someone dies?
Absolutely. That's actually a very common scenario for proprietary estoppel claims. Cases like Rebasham 1986 and Whaling v. Jones 1993 dealt with exactly that.
Rebasham, Whaling v. Jones.
And it was confirmed by the highest court, the House of Lords then, in Thorner v. Major. That's Thorner v. Major, 2009, a very important case for proprietary estoppel.
Thorner v. Major. And who gave the key judgment there?
Lord Hoffman. Yes, Lord Hoffman and Thorner v. Major. He stressed that the assurance has to be clear enough. Not necessarily explicit, but clear enough in the specific context of the relationship and dealings between the parties. So Thorner v. Major is crucial for understanding how clear an assurance needs to be in proprietary estoppel.
Okay, Lord Hoffman and Thorner v. Major. So assurance, reliance, detriment, and this overarching idea of unconscionability. It seems like these elements might overlap a bit in practice.
They definitely do, and the courts have recognized that. They often talk about taking a holistic approach. We mentioned Gillette v. Holt before.
Yes, Gillette v. Holt.
Well, Gillette v. Holt, and another key case, Jennings v. Rice, 2002, they both emphasize looking at the matter in the round.
Jennings v. Rice, okay.
It means you don't just rigidly tick off boxes for assurance, reliance, detriment, and proprietary estoppel. You look at the whole story, the interactions, the context, to see if denying the claimant some relief would be, well, unconscionable. It's about the overall picture.
Right, a holistic view. That makes sense. Okay, so let's say a claimant manages to jump through all those hoops. They establish the assurance, the reliance, the detriment, and the court agrees it's unconscionable. They've established an equity under proprietary estoppel. What actually happens then? What's the remedy?
Ah, the remedy stage. This is where the court decides how to satisfy the equity in a proprietary estoppel claim. And honestly, the range of possible remedies is huge. The court has a lot of discretion.
So it's not automatically you get the house.
Definitely not automatically. It can be the transfer of the property itself. We saw that in Pasco v. Turner. That's Pasco v. Turner, 1979, where the claimant actually got the freehold.
Pasco v. Turner. Wow. The whole freehold.
Yes. But it could also be financial compensation, like money. That happened in Campbell v. Griffin, 2001.
Campbell v. Griffin.
Or sometimes it's a mix of things. Gillette v. Holt, again, Gillette v. Holt involved both a transfer of property and a sum of money. So lots of flexibility in proprietary estoppel remedies.
Okay, so how do the courts decide? Is there a guiding principle?
Well, there's been a lot of debate about that, but a really significant recent case from the Supreme Court has clarified things quite a bit. That's Guest v. Guest. Guest v. Guest, 2022.
Guest v. Guest, 2022. That sounds important for proprietary estoppel remedies.
It is. The majority decision in Guest v. Guest said the main aim, the central purpose of the remedy in proprietary estoppel, is to prevent or remedy the unconscionable conduct, the promisor breaking their promise.
Okay, preventing the unconscionable conduct.
And they said the starting point for figuring out the remedy should usually be to try and fulfill the claimant's reasonable expectation. So hold the defendant to their promise, essentially.
So if you are promised the farm, the starting point is you should get this farm. or something equivalent.
Pretty much, yes. That's the expectation-based starting point from guest v. guest. However, and this is crucial, they also said that if fulfilling that expectation would be out of all proportion to the detriment the claimant actually suffered.
Proportionality.
Exactly. Then the court might award a lesser remedy, perhaps something closer to just compensating for the detriment. So guest v. guest brings in this check of proportionality for the remedy in proprietary estoppel.
Was everyone agreed on that in guest v. guest?
No, there was a dissenting view. The minority in guest v. guest preferred an approach focused primarily on reversing the detriment suffered by the claimant, doing so in the way that was least burdensome for the promisor. So still some debate, but the majority view in guest v. guest expectation as the starting point, checked by proportionality, is the current leading approach to proprietary estoppel remedies.
I see. Expectation first, but keep an eye on whether it's disproportionate to the detriment. It sounds like a balancing act for the court in proprietary estoppel cases.
It really is, and this connects to an older idea sometimes mentioned in proprietary estoppel.
Yeah.
The minimum equity to do justice. The idea that the court should award no more than is necessary to fix the unfairness, the unconscionability.
Minimum equity.
Sometimes that minimum might just be compensating for the detrimental reliance. And in some rare cases, like Sledmore v. Dalby, that's Sledmore v. Dalby, 1996, the court might even find that any detriment suffered has already been outweighed by benefits the claimant received, like living rent-free for years.
Sledmore v. Dalby. So you could end up with nothing, even if you establish an equity.
It's possible, yeah, if the detriment is considered exhausted. Sledmore v. Dalby shows that. It underlines how crucial the detriment element is throughout the proprietary estoppel analysis.
Okay. Can you give a few more quick examples of the kinds of remedies awarded in proprietary estoppel, just to see the range?
Sure. We've seen courts award compensation specifically for money spent, like in Dodsworth v. Dodsworth, Dodsworth v. Dodsworth v. Dodsworth, 1973, or Burroughs and Burroughs v. Sharp, that's Burroughs and Burroughs v. Sharp, 1991.
Dodsworth v. Dodsworth, Burroughs and Burroughs v. Sharp. Financial compensation.
Yeah. Or rights over land, but not ownership, like a right-of-way or access, as in the famous case Crabb v. Arun District Council. Crabb v. Arun District Council in 1976.
Crabb v. Arun District Council. Access rights.
Or even something like a right to live in the property for life, a sort of non-assignable lease, which happened in Griffiths v. Williams, 1977.
Griffiths v. Williams, a life interest. Okay, so the remedy in proprietary estoppel is incredibly tailored to the facts.
Absolutely. And as Jennings v. Rice again indicated, the scale of the expectation versus the scale of the detriment often influences the outcome. It's all about achieving a just result in the specific circumstances of that proprietary estoppel claim.
Right. Now, a really practical question. What if the person who made the promise, the landowner, sells the property before the claimant gets a court order? Does this proprietary estoppel claim affect the new owner?
Ah, yes, the third-party issue. This is critical. The Land Registration Act 2002, the LRA 2002, actually addresses this directly in Section 116.
LRA 2002, Section 116, what does it say?
Section 116 of the LRA 2002 clarifies that an equity by estoppel, so the potential right that arises once the elements are met, takes effect from the time it arises as an interest capable of binding successors in title.
Okay, wait. So the potential proprietary estoppel right exists as a property interest even before the court declares it, from the moment the detrimental reliance on the assurance happens.
That seems to be the effect of Section 116 LRA 2002, yes. It means the proprietary estoppel equity itself can potentially bind a purchaser or transferee.
How? How does it bind them?
Well, for registered land, which is most land now, the proprietary estoppel equity needs to be protected, either by putting a notice on the land register, or if the claimant is in actual occupation of the land, it might potentially qualify as an overriding interest, which binds even if not registered.
Actual occupation. Okay,
Yeah.
So proprietary estoppel plus living there could bind a buyer.
Potentially, yes. For unregistered land, the old rules about notice would likely apply to the proprietary estoppel equity. But then once the court actually awards a specific remedy, then whether that remedy binds a later purchaser depends on what the remedy is. If the court awards, say, the freehold or an easement, those are definite property rights and will bind purchasers if protected correctly. But if the remedy is just a personal license to occupy or purely financial compensation, those generally won't bind a third-party purchaser.
Got it. So the initial proprietary estoppel equity might bind under LRA 2002, Section 116, but the final awarded remedy's binding effect depends on its nature. That's a really important distinction.
It is.
Okay, let's maybe quickly touch on a few more cases just to reinforce some of these points about proprietary estoppel.
Good idea. A well-known one is Cobb v. Yeomans Row Management Ltd. That's Cobb v. Yeomans Row 2008, a House of Lords decision.
Cobb v. Yeoman's Row. What's the takeaway there? Lord Scott gave the judgment, I think.
Yes, Lord Scott. Cobb v. Yeomans Row is often seen as a bit of a break on proprietary estoppel, especially in commercial settings. The claimant was an experienced developer. They had an oral agreement in principle, but both sides knew a formal contract was needed. When the deal fell through, his proprietary estoppel claim failed.
Why did the proprietary estoppel claim fail in Cobb v. Yeoman's Row?
Well, Lord Scott basically said proprietary estoppel shouldn't be used to bypass the need for contractual certainty when experienced commercial parties deliberately don't finalize a formal deal. They knew they didn't have a binding contract. So, Cobb v. Yeoman's Row limits proprietary estoppel where parties consciously rely on sort of non-binding understandings in a business context.
Right. So proprietary estoppel isn't a get-out-of-jail-free card for failed commercial negotiations.
Not usually, no. Then there's Henry v. Henry, 2010. Henry v. Henry, that was a Privy Council case dealing with proprietary estoppel.
Henry V. Henry. What did that add?
It reinforced that when assessing detriment for proprietary estoppel, you have to weigh up the disadvantages against any advantages the claimant gained. It's a balancing act. And Henry v. Henry also strongly emphasized proportionality when deciding the remedy. That idea we discussed from Guest v. Guest later, it was already brewing in cases like Henry v. Henry.
Proportionality again. Seems central to the remedy stage of proprietary estoppel.
Very much so. Southwell v. Blackburn, 2014. Southwell v. Blackburn.
Yes, Southwell v. Blackburn. Tomlinson, LJ.
That's the one, Tomlinson, LJ. A good example of non-financial detriment in proprietary estoppel. The claimant had given up a secure tenancy and job security based on promises of a secure home with the defendant. The court found this was significant detriment, awarding her compensation when the relationship ended. It highlights the secure home concept in proprietary estoppel.
Giving up security is detriment. Okay, what about Moore v. Moore, 2018? Moore v. Moore, Henderson, LJ.
Yes, Moore v. Moore, Henderson, LJ. That involved a family farming partnership breakdown. The son had relied on promises about inheriting the farm. The relationship soured badly, and the Court of Appeal thought forcing them to continue working together was impossible. So instead of giving him the farm directly then, they structured a remedy aiming for a clean break, providing him with significant financial provision to allow him to farm independently. Moore v. Moore shows the court adapting the proprietary estoppel remedy to messy relationship breakdowns.
A clean break remedy. Interesting. Are there cases where proprietary estoppel claims just fail because the assurance wasn't clear enough?
Oh, definitely. James v. Thomas, 2007, James v. Thomas is an example. The assurances given were quite vague, like this will benefit you or you'll be all right. The court felt these weren't specific enough to found a proprietary estoppel claim relating to the property itself, especially as there wasn't enough evidence of a common intention that she would get a share. So, James v. Thomas shows vague hopes aren't enough for proprietary estoppel.
Needs to be clearer than that. James V. Thomas.
Indeed. But proprietary estoppel isn't just for family. Wills v. Sauray, 2020, Wills v. Sauray was a successful high court claim by non-family members who'd worked on a farm for years based on repeated promises they'd inherited. The high court judge upheld their claim. So Wills v. Sauray shows the doctrine applies more widely.
Wills v. Sauray. Good to know. It's not just family disputes. One last one, maybe. Howe v. Gossip, 2021. Howe v. Gossip. Snowden J. It mentions Section 2 of the Law of Property, Miscellaneous Provisions Act, 1989.
Yes, Howe v. Gossip, Snowden J. That act, the Law of Property, Miscellaneous Provisions Act, 1989, Section 2, requires contracts for land to be in writing. The question was whether an oral agreement, unenforceable under Section 2, could still support a proprietary estoppel claim.
And could it, according to Howe v. Gossip?
Yes. Snowden J. held that proprietary estoppel could be raised as a defense to a possession claim, even if the underlying oral agreement was void under Section 2 of the 1989 Act. It shows that proprietary estoppel can sometimes operate outside those strict formality rules to prevent unconscionable conduct. Howe v. Gossip confirms proprietary estoppel can act as a shield in these situations.
Proprietary estoppel as a shield against strict formality rules.
Yeah.
Interesting point from Howe v. Gossip. Wow, okay, we've covered a lot of ground there on proprietary estoppel.
We certainly have.
So just to wrap things up, what are the absolute key things you think listeners should take away about proprietary estoppel?
Okay, key takeaways for proprietary estoppel. First, remember the core elements. You need an assurance or representation, reliance on that assurance, detriment resulting from that reliance, and overarching all of that, it must be unconscionable for the promisor to go back on their word. Remember those four: assurance, reliance, detriment, unconscionability.
Assurance, reliance, unconscionability. Got it.
Second, if you establish those, the court has wide discretion on the remedy. It's not automatic. The starting point, after guest v. guest, is often the claimant's expectation, but it must be proportionate to the detriment. The remedy could be property, money, rights, or a mix. Think Pasco v. Turner, Campbell v. Griffin, guest v. guest.
Wide remedies. Expectation versus detriment proportionality. Check.
Third, case law is king in proprietary estoppel. Understanding cases like Ramsden v. Dyson, Gillette v. Holt, Thorner v. Major, Jennings v. Race, and Guest v. Guest is absolutely vital to see how the principles work.
Case law, case law, case law.
Right.
Especially Ramsden v. Dyson, Gillette v. Holt, Thorner v. Major, Guest v. Guest.
Yes. And finally, remember Section 116 of the LRA 2002. That proprietary estoppel equity arises early and can potentially bind third parties if protected, either via the register or sometimes actual occupation. LRA 2002, Section 116.
Section 116 LRA 2002 and third parties. Okay, so proprietary estoppel. It's flexible. It's about preventing unfairness, unconscionability based on assurance, reliance, and detriment, with wide-ranging remedies heavily guided by case law.
That's a pretty good summary. It's equity trying to do justice when strict property rules might not.
So here's a final thought for you, our listener, to maybe mull over. Given how flexible proprietary estoppel is, and especially after guest v. guest put the focus initially on expectation, how do you think the courts are going to continue balancing that expectation against the need for proportionality with the detriment suffered? Where will that line be drawn in future proprietary estoppel cases?
It's a real tension, isn't it, between sticking to promises and, well, fairness in the remedy itself.
Yeah, that's the ongoing challenge, finding that balance. A great question to think about.
Definitely. Well, thanks for joining us for this deep dive into the fascinating world of proprietary estoppel.
My pleasure.
Until next time.